Welcome to U.S. Immigration. In this video we will discuss about July 2021 and future visa bulletin predictions from the State Department. Charlie Oppenheim, chief of the Visa Control and Reporting Division from the U.S. Department of State, provided some insight and predictions related to the July 2021 and future visa bulletin in their official channel on May 24, 2021. Mr. Oppenheim's prediction covers rest of fiscal year 2021, which runs through September 30. If you are interested in this topic, please stick around till the end of this video. For your immigration news and updates, please like this video and subscribe to the channel. Do not forget to hit that notification bell. Let's get into the video. What Charlie does. Charlie, he issues the visa bulletin each month around 10th and fixes the dates on the bulletin based on demand for visas. Since these visa categories are numerically limited, meaning that only a set number of visas are available each fiscal year, the more demand, the more the dates will move backward or stay the same. If there is less demand, the dates move forward. Important responses from State Department is trimmed and presented in this video. You can check the complete interview in State Department official link. State Department will hold future sessions soon after the visa bulletin is published. The information regarding that will also be published in the visa bulletin. As per the State Department, usage of family-based visas remains low. The usage of family-based immigrant visas remains low due to the ongoing pandemic. This is because over 95% of family-based immigrant visas are processed by consular posts overseas, many of which have very limited visa appointments available. Let's get into general questions before discussing specifically on employment, family, and diversity visa questions. Do you expect family-sponsored and employment-based annual limits for fiscal year 2021 will be reached?
No, we do not believe that, based on the implications of the COVID-19 situation and other issues which have impacted processing since October, we do not expect that those limits will be reached. The processing of cases at our overseas posts has resumed in recent months, but we're still not at the normal processing levels. And my guess is that the USCIS offices are facing the same processing issues.
What will be the numbers in terms of family-sponsored and employment-based annual limits for fiscal year 2021?
Under the current INA guidelines, we expect that the family-sponsored annual limit will once again be 226,000. It has been that way since about fiscal 2000. And for the employment-based limit, I now expect that the limit will be at least 290,000 for fiscal 2022. That will be another all-time high in terms of the employment limit.
How is final action date for each month determined?
We consider a number of variables when making the determination of the dates based on preference category annual limits. For example, the overall per country limits and category limits. We determine how many numbers have already been used, how many additional numbers we expect to be used during the current month, and the amount of known demand for which number use might be required based on the movement of the final action dates for the upcoming month. Those are just a few of the variables that are involved. There's a number of others, but those are kind of the highlights.
Do USCIS share the amount of cases they have in various stages of processing?
Yes, we're very lucky. One, the USCIS Ombudsman's Office hosts a monthly meeting at which State Department, USCIS offices, and sometimes other government agencies are on the call or the in-person meeting in earlier times. We discuss the number of situations, and at the beginning of each month, USCIS provides us with a very detailed report indicating the amount of demand they have, which is in various stages of processing in the various categories. We use that information in the determination of the final action dates, knowing that such demand could require the use of a number during that upcoming month. For example, at the beginning of May, I received the report. I was able to look at that and based on the information there, determine what the June employment dates should be based on the likelihood numbers would be used during June.
At what point visa number will be allocated to be used by applicant, based on determination of monthly final action dates?
If the applicant has already been reported to our office as being documentarily qualified, meaning they've submitted all of the required documents that are normally required at the time of visa interview, and their priority date is within the newly announced final action date, then numbers are immediately allocated for potential final action on their case. Then throughout that month and the upcoming month, numbers are continually allocated as new cases can be finalized, because all of the required processing on them have also been received and finalized. For example, I believe one of the questions last month was about the USCIS offices requesting additional information on the case. For example, a new medical, etc. Well, that new medical is received, and then immigration would then, once it's received, they could request an additional number for use by that applicant.
Do you expect any final action dates to be retrogressed?
No, we do not expect any of the family-sponsored or employment-based final action dates to be retrogressed, either in fiscal 2021 or for the foreseeable future in fiscal 2022.
Will all the spillover visas go to one specific country if it's most backlogged country?
No, what the spillover is, we are currently estimating that there will be approximately 150,000 unused family-sponsored numbers. Those 150,000 numbers get added to the 140,000 minimum employment-based annual limit, resulting in the 290 figure. Then the Immigration and Nationality Act guidelines, which indicate that in the employment first, second, and third preference categories, those preference categories are entitled to 28.6% of the annual limit, and the fourth and fifth preference are entitled to 7.1% of those annual limits. Then there is also a 7% per country annual limit, which is applied to that 290,000 figure. And once that per country limit is established, then once again, those 28.6 and the 7.1% limits are imposed to the availability of numbers within an individual country. So again, the Immigration and Nationality Act guidelines imposing the 7% annual limit, the intent is to prevent a handful of countries from potentially monopolizing all of the available numbers, giving an equal chance at applicants around the world to have use of the numbers. And then if the numbers are not being used in the various employment categories, then they can be those, quote, otherwise unused numbers under the annual limit can be provided to the countries which have applicants with the earliest priority dates.
If USCIS doesn't use all the visas available, does State Department have authority to make all priority dates current?
The way the final action dates are determined, we have a number use target for a given month. We compare that target with the amount of numbers available and the demand. So we look carefully at the amount of demand which potentially could utilize the available numbers. If there is not sufficient demand that we can see, then a category, for example, in the worldwide employment third preference category, that is currently deemed to be current because the level of demand that we have on file at this moment is not sufficient to fully utilize all the available numbers. But if we were able to see the demand was there, we might have to establish a final action date.
For this year, how many available visas have been already used, and how many will be expected to be used by end of the fiscal year?
We do not publish mid-year figures or discuss that. In terms of number use, I do believe both on the family and employment side, there will be significant amounts of unused numbers under the annual limit. We are hoping that proves not to be the case through continuing efforts to utilize visa numbers. For example, during the summer months of 2020, last summer, We did not expect the employment annual limit to be reached then, yet the extraordinary efforts of USCIS in terms of being able to process cases during the summer months allowed the vast majority of the employment numbers to actually be utilized. So we continually monitor the situation. And again, the aggressive movement of the employment dates have been done in a manner to potentially maximize number use by making numbers available to qualified applicants.
In what order applications are processed? Are they based on priority dates, received dates, or notice dates?
It would be, I cannot speak to the USCIS processing, but from at the State Department, it's based on when the applicants become documentarily qualified, meaning they've submitted all the required requested documents to our National Visa Center, and then have been reported to the visa office for consideration. The cases will be processed in that order that they were originally provided to the visa office.
Let's get into family-based questions and responses from Charlie. Do you expect worldwide family-based dates will continue to move in fiscal year 2021?
Originally, we had expected the movement of the family dates to have slowed or stopped for the summer months. But based on changing conditions at our overseas posts, which are allowing additional numbers to be utilized, there is an excellent chance that we will be able to continue advancing many of the family dates through the summer.
F4 retrogressed last year. It did not move much after that in 2021. What will be the F4 date movements going forward?
On the fourth preference, the date did retrogress in fiscal 2020. The reason being, throughout fiscal 2019, the response rate by applicants who had been requested to assemble and submit required documentation was extremely low. So the worldwide family fourth preference date had been advanced at a very rapid pace to try to maximize number use under the family sponsored fourth preference. Then eventually the response rate did start picking up, and therefore we had to retrogress it because the amount of available numbers was insufficient to meet the new demand. And we've been slowly recovering from that retrogression during the course of the last year and a half.
Why difference between filing and final action dates gap vary for different country? A special example will be F4 India.
With the application filing dates, they are established at a point where we believe the final action date is likely to reach within the next 8 to 12 months. The amount of applicants in the India family fourth preference category which have applied and submitted all the required documentation is sufficient within that roughly 6-month period to utilize all the numbers we believe will be available in the near future. Once that level of demand starts to be diminished, then the application filing date for India fourth preference would be advanced. And those dates are established and advanced depending on the various preference categories.
Family F1 filing dates are moved aggressively. Will the same movement will be done on priority dates too?
With the application filing dates on the family categories, family first preference, once again, we wanted to stimulate applicant responses so that we could generate sufficient demand to fully utilize the available numbers. The advancement of the family first preference final action date has also been done in a manner to allow enough applicants to be ready to go and potentially use all of the available numbers under that limit. The first preference annual limit is to 23,400. So by the end of the year, we want to have a date which would generate enough demand to allow all those numbers to be utilized.
When you expect F3 final action date will have strong forward movement?
Again, in the family third preference, as I mentioned earlier, the dates have already been advanced at an aggressive pace to maximize potential number use under this year's annual limits. Therefore, To the extent we're not able to utilize those numbers, we will already have them, quote, on hand, ready to go as we move into fiscal 2022. That is the reason I believe that at some point, the family-sponsored dates in many or most preference categories are likely to be held for an extended period of time, because we will already have enough applicants, quote, queued up, ready to go based on the existing dates, and therefore we do not need to continue to advance those dates.
Let's get into diversity visa questions. Do you expect any diversity visa 2021 rank cutoff to be retrogressed?
No, all of the DV rank cutoffs will remain current through the end of the DV 2021 program. One other additional comment in terms of final action dates as we move forward. We do expect that final action dates will be held for an extended period of time once our overseas posts do return to completely normal operating status, most likely sometime in next year that when they'd be held. And the reason being that the dates which have already been established that will provide sufficient demand to probably utilize the vast majority of the 2022 numbers, at least for the first half of the year, potentially moving forward into the second half again.
How does Kentucky Consular Center for Processing Diversity Visa prioritize cases?
The Kentucky Consular Center, KCC, handles all of the documents that are submitted for overseas processing of diversity visa categories. Once again, they would be processing in the order that the cases became documentarily qualified. So it is my understanding that for both the family and employment cases and the diversity cases, a case that was submitted in October would be scheduled for interview before a case that only was became qualified and reported to the visa office in March. So again, we're taking the cases in the order that people became ready, be it for not for the the issues with COVID and the post-processing limitations.
What purpose was served by making DV 2021 visa numbers available over 100,000 when consulates issued only 20 DV visas?
And we schedule or have the registration period for each year's diversity visa program. We always select enough applicants to help ensure that we can maximize number use under the annual limits. It's important to remember that a lot of people that apply for the diversity visa program, they may not follow through with that registration, even if they're selected for whatever reason. Sometimes applicants will be refused upon their interview, or again, like I said, they may not proceed. When we had the DV 2021 registration period and made the selection of applicants, the registration period was pre-pandemic, and the selection was made last spring, but we have to proceed under the assumption that normal processing could return at some point. That allows us to potentially maximize number use under the various annual limits. If we had not registered applicants and miraculously this COVID had suddenly gone away, then we would have been in the situation where we did not have applicants for the numbers that could have been used. It is also important to remember that all of the diversity information on registration clearly indicates that selection to participate in the program does not guarantee visa availability. So that is a very important thing to remember.
As per the State Department, rapid advancement of employment-based visa categories happens for the rest of fiscal year 2021. Due to the low usage of family-based visas, the potential available employment-based visas for the next fiscal year will be at least 275,000. This will have a positive impact on EB visa availability for China and India. Let's get into the questions. Do you expect employment dates for India and China will continue to move?
Yes, We will continue to advance those dates and most other employment dates as well, with a probable exception of the employment fifth preference category for China, but all other employment dates will be moved aggressively through the end of the summer and most likely in the early part of fiscal 2022 as well.
Okay.
Again, based on the expected exceedingly high annual limit for 2022.
Which countries will usually use major employment-based visa numbers?
China and India typically use the vast majority of the employment numbers. The reason being these applicants have the earliest priority dates, and also if there are otherwise numbers available under the annual limits, those otherwise unused numbers can be made available strictly in priority date order to the applicants with the earliest dates. Again, those being typically China, most likely India, particularly in the India employment second and third preference categories.
Will any EB2 or EB3 employment date retrogress in 2021?
We do not believe that'll happen. Again, with the anticipated high limit for 2022, I think that everybody can assume that all of the employment dates will continue to be advanced at a very aggressive pace, at least for the first half of the year. Then depending on the amount of new filings and processing rates, things may slow down or have to be held at some point during the second half of fiscal 2022.
How much movement we can see for EB3 in July 2021 Visa Bulletin?
Once again, it will be very aggressive. I think it's safe to say that most, if not all, of the application filing dates, which are listed for employment in the chart B of the bulletin, with the exception of China EB5, will be reached by the end of the year. So again, expect very aggressive movement of the employment dates for the month of July.
When can we expect EB3 to be current for 2016?
Worldwide third preference is already current. China third preference is in 2018, with the India third preference date being in 2011. I think that the India third preference date is likely to advance into 2012 in the near future. Beyond that, we will have to continue to watch incoming demand.
What will be the spillover from family to employment-based category this year?
My prediction, as I mentioned earlier, I expect that the fall across under the INA guidelines of unused family numbers, which are automatically added to the employment annual limit for the following year, I believe that will result in the fiscal 2022 employment-based limit being at least 290,000.
Why filing dates are extended when USCIS is not accepting applications based on filing chart?
State Department has no jurisdiction over what they may choose to do, but we continue to advance the application filing dates because that allows our National Visa Center to contact the eligible applicants based on the movement and ask them to begin assembling and submit the required documentation. That is an excellent way for me to gain much needed visibility into potential demand when and if I were to move the final action dates. And the Immigration Service has a formula which they use to decide whether only the final action dates or a combination of the final action and application filing dates will be allowed to be used. I would suggest that listeners carefully monitor the USCIS website, which provides that information on whether the application dates will be able to be used for the upcoming months. And at this point, I fully believe that the dates which are announced in the October Visa Bulletin for application filing dates, I fully expect those to be allowed to be used for filing. That has been the standard policy in recent years.
Hope the information presented in the video is useful. U.S. Immigration Channel will be releasing a video when additional information is available on any of these program or regulations. If you have not subscribed, please like this video and subscribe to the channel. Do not forget to hit that notification bell. See you soon in our next video.